Well, from one Richard to another, thank you very much, and congratulations on your future appointment. That's great. Coming up 11 years after 9/11, it's really inconceivable that any terrorist group, let alone one that's connected with Al-Qaeda, could mount and finance a similar attack through public appeal. And furthermore, given the visibility and transparency and scrutiny, indeed, of all financial transactions conducted through the formal banking sector, any financier of terrorism who sought to finance an operation like that in such a way would be taking huge risks. It's also true that today the threat of global terrorism is on the decline. So far as Al-Qaeda is concerned, the vision of people like Abdullah Azzam, who promoted the idea of global terrorism, and of Osama bin Laden, who carried it out, have really faded away. Even among the Al-Qaeda leadership, the emphasis has returned to action on local fronts, or against the near enemy, rather than against the far enemy, as it was before. And although some local groups certainly retain a capability to mount attacks elsewhere, they're less threatening to global peace and security today than at any time this century. The associations between terrorist groups that profess similar ideologies is now far more evident in their verbal communications than in any effective operational cooperation. So the first question I would like to ask is, are these things two things connected? The difficulty that terrorist groups face in raising, storing, and moving money, and their increasing lack of viability. Well, it's tempting to answer yes, and indeed many people do so without much reservation, particularly those legislators and regulators who are the architects and supporters of the countering the financing of terrorism regimes that now cover most of the world. There's been a huge investment in countering the financing of terrorism as a result of regulation introduced since 9/11, and most of it has been extracted from the private sector. Almost all of this effort has focused on terrorist financing through the formal banking system, with some more recent attempts to include other money or value transfer services, cash couriers, and the not-for-profit sector. Not only have CFT regulations made it harder for potential donors to send money to terrorist groups, but along with the introduction of new rules in areas such as customer due diligence, they've raised the awareness of the possibility of terrorist financing among front-end staff at banks and other financial institutions. The 9/11 Commission found that the 19 hijackers responsible for those attacks had opened bank accounts, had established interconnecting drawing rights, had received several international money transfers, and had generally paid very little heed to the possibility that their financial activity could alert anyone to their plans. There's no doubt that if an investigator had had reason to suspect one member of that group, given time, he could have unraveled the plot as well as its overseas sponsors with the help of relevant banking records. Indeed, the hijackers were so unconcerned about surveillance of their financial transactions that they made arrangements to return any surplus in their accounts at the time of their deaths to the Al-Qaeda central pot. But if there was a failure in joining the dots before 9/11, it was not in the area of investigating Al-Qaeda's financial arrangements. The 19 hijackers did nothing that stood out or was in any way illegal. And the 9/11 Commission went so far as to suggest that even in the high state of anxiety and raised awareness that followed the attacks of September 2001, similar transactions would probably very likely still go unremarked. This may be less true today, but in the millions of transactions that take place every day, it generally requires an additional piece of information to draw attention to any specific activity, even in the formal banking sector. The search for terrorist financing indicators, as shown by the forthcoming study conducted by Professors Sue Eckert, Richard Gordon, and Nikos Passos through this last year and the year before, on the information available to them, has turned up nothing that could be used as a particularly reliable guide on its own. And another important point is that the perpetrators of the 9/11 attacks were not raising money. They were merely receiving and spending it. And the money that they used was transferred from central funds of al-Qaeda through cutouts to their accounts in the United States. Where and how terrorists raise money is important to their security and, of course, to their ability to mount attacks. And it's as important as their moving and storing it. The thing about raising money is the same as with spending money, that it brings you inevitably into contact with other people outside your circle, and therefore outside your control. It makes terrorists more vulnerable to detection, and furthermore, donors, especially wealthy ones, have become much more cautious about giving to terrorist groups, as the risks to their livelihood and reputations, and even to their liberty, have grown as investigators have increased their knowledge of terrorist groups and their scrutiny of their contacts. Donors are more conscious about and cautious about dealing with people they do not know, at the same time as the capture, death, and exposure of many old-time fundraisers has forced terrorist groups to deploy new faces. There have been several cases reported where a fundraiser has had on his cell phone his picture, along with that of a terrorist leader, and a message from the leader to vouch for his bona fides, to reassure a prospective donor that this is not going to turn out to be an entrapment or a sting operation. Also, although there is evidence that donors still give money to terrorist groups, there are plenty of other causes for them to support. The Arab Spring appears to have diverted funds from terrorists to other non-violent protest groups, especially money that was previously solicited in support of attacks on unpopular regimes. Also, donors have got wise to the soft appeals for money, for example, on behalf of the widows and orphans of terrorists. They know that, in fact, the money is much more likely to go to further terrorist acts rather than to support those dependents. And as terrorists have become more obsessed with local, intercommunal, and interethnic disputes, donors that might have given support to an organization that was fighting, for example, foreign intervention or government repression, have become disillusioned and less motivated, especially as foreign intervention has receded. Increasingly, therefore, terrorists have looked to other ways to raise money, mainly by boosting their criminal activity. Kidnapping for ransom, for example, has become a particular popular pursuit with terrorists, including the senior leadership of al-Qaeda. There's a trial currently in Pakistan of an ex-Pakistan army major who's alleged to have been commissioned, in fact, by al-Qaeda to conduct kidnaps on their behalf for ransom. And al-Qaeda is believed to have benefited greatly from the kidnap and release of a very senior Iranian diplomat in 2008, who was released in 2010. And al-Qaeda in Islamic Maghreb, which is one of the most active groups at the moment, of course, is particularly famous for kidnapping for ransom and has gathered hundreds of thousands of euros from this particularly kidnapping Westerners. And that has not only helped it fund its own activities, but also the activities of Boko Haram in Nigeria, which has also captured the news a lot recently. And Boko Haram, apart from getting that sort of money, has had a past speciality in bank robbing and car hijacking and other forms of violent crime which can give them money. And in Iraq, too, if you think about what's going on in Iraq, kidnapping, very common, bank robbery, knocking off jewelry shops, these things these sorts of criminal activity are their main sources of income. Al-Shabaab, which has also been in the news very much recently, particularly as it's now been recognized by al-Qaeda as an affiliate, has several different ways of raising money, not all of them criminal in the exact sense of the word, in that they tax local businessmen, they mount tolls on roads, they take a big part in the charcoal trade in Somalia, and operate a large port, Kismayo, which is a big center for imports and exports. But fundamentally, terrorist groups, although they are still able to raise money, can do so far less easily and more sporadically than previously. And their methods have become much more closely aligned with mainstream criminal money-making schemes, whether on a major or minor scale. And for most terrorist groups, this has seriously undermined their capacity to mount large attacks. The ability of al-Qaeda, for example, to mount a similar attack to the 9/11 attacks is almost non-existent just now. So this has led to a new form of terrorism, and Ayman al-Zawahiri and other leaders of al-Qaeda have made clear to their supporters that they shouldn't look to the center or rely on the center for financing or even training, but should use whatever resources they can find at their disposal in their own locality. And this, of course, has led to smaller attacks, less coordinated attacks, and attacks with less international impact. Of course, terrorist groups aren't necessarily hierarchical, and they do not have sophisticated financial management systems. But despite that, there's no doubt that the international regime designed to counter the financing of terrorism has played a part in limiting their capacity. We can say that with some certainty about the groups we know of, but if you think of the individuals, the lone perpetrators of the Counter-terrorism, like in Norway in July of last year, where a guy called Breivik exploded a bomb in the center of town which killed 8 people, and then proceeded to go to an island where there was a sort of youth camp where he shot a further 69 people dead. And from those attacks, another 151 people were injured, so it was a serious attack. But he acted on his own, he raised his money on his own, largely legally, but also through some credit card, well, not quite fraud, maybe more borrowing. And he was able to really grab the headlines, do all the things that terrorists want to do. And at some cost, not an inconsiderable cost, but nonetheless one that he was able to meet himself. So, although the opportunities for large terrorist groups are less, nonetheless the opportunities for terrorism, of course, continue to exist. And although the attacks may be less devastating than 9/11, they're no less effective in drawing attention to causes and raising the levels of public anxiety. The reason for the decline in terrorism, I'd like to mention a little bit, which I think is mostly to do with the appreciation among vulnerable communities that terrorism doesn't deliver what its proponents advertise. And furthermore, apart from this lack of credibility, terrorist groups have lost any claims that they may have had to legitimacy. Terrorism in Muslim-majority countries in particular, such as Iraq, for example, and Pakistan, does far more harm to the community that terrorists profess to defend than to any imaginary or real enemy. And the justification for terrorist activity is increasingly exposed as bogus and unsubstantiated, even by those who agree with its stated aims. And of course, the third area where terrorism has lost momentum is, as I said, in the growth of popular non-violent movements and the evidence of their success. And that's not just a factor of the Arab Spring, although the examples of Tunisia and Egypt, of course, are instructive and show the irrelevance of violence to terrorism in the achievement of lasting political change. There are many other global protest movements where you see no al-Qaeda black flags fluttering in any sort of way. And even those like in Syria and Yemen, where although al-Qaeda in the Arabian Peninsula has tried to get purchase, there's actually very little that they're doing to promote the political change that the majority of Yemenis want. And of course, if you think of Zuccotti Park or other Occupy Wall Street venues or protests in New Delhi about corruption and things like that, you don't see any terrorist supporters rattling cans or professing to be influencing events. And it's true, I think, that the protesters in Tahrir Square have achieved more in a matter of a few months that Ayman al-Zawahiri, who's also Egyptian, has achieved in his terrorist career, which has lasted now more than 45 years. So when I ask that question, are the difficulties that terrorist groups face in raising, storing, moving money the reason for their increasing lack of viability, I can only say that yes, to a certain extent. The two things are connected, but they're not necessarily in a direct relationship of cause and effect. Terrorists are facing difficulties in all areas, not just financial. They have difficulty projecting their message, they have difficulty gaining support, they have difficulty proving their relevance, and most importantly, they have difficulty mounting attacks. So the second question I'd like to ask is, are the international efforts to counter the financing of terrorism worth the effort and resources required? Now, it's inevitable that the bureaucratic response to a problem should lag behind the problem itself. And it's perhaps only now that we are beginning to work out the best approach to countering the financing of terrorism. 8 of the 9 special recommendations of the Financial Action Task Force on terrorist financing were adopted in October 2001, commendably soon after the attacks of 9/11, but perhaps the worst time to craft an effective and balanced response. And it was only in February of this year, after a great deal of consideration and debate lasting 2.5 years, that FATF recast its 40 recommendations on anti-money laundering and its 9 special recommendations on countering the financing of terrorism and amalgamated them into one group. And this process provided a very timely reappraisal of the special recommendations. Most notably, it emphasized the importance of states taking a risk-based approach to terrorist financing, which means that states can do less in areas where they assess the risk to be low, though they should, of course, conversely do more where they see the risk to be high. The proponents of a risk-based approach to terrorist financing have long argued that a blanket application of rules and regulations, especially in states with a less developed financial services sector, sets the stage for failure. No state was ever judged fully compliant with all 9 special recommendations, and the awareness of the challenges of implementation may have led to some states to try less hard than they might to become at least partially compliant. Where states are encouraged to focus on areas of particular vulnerability and judged by their neighbours on their performance against those risks, they are more likely to achieve an appropriate level of protection. And the same is true for the private sector, which is also encouraged by the FATF recommendations and their interpretive notes to take a risk-based approach. Much of the private sector has been an enthusiastic partner in trying to counter the financing of terrorism. Banks and other financial institutions have looked to states for guidance and have been prepared to absorb the costs associated with complying with a raft of new regulation. They are effectively paying to turn away business. But in the absence of feedback and briefing on where their efforts can do most good, many private sector companies have begun to see their main objective as avoiding falling foul of the regulator rather than making a significant contribution to the suppression of terrorism. And this is not a criticism. States cannot expect the private sector to have a better idea of what terrorist financing looks like than they do themselves. States generally only learn how a terrorist crime has been financed once it has happened, and an investigation has turned up the information. And even then, the financing of one operation has rarely, if ever, replicated the financing of another. Where a terrorist attack has been funded by credit card fraud or some other common offence, it has generally not been possible, even with hindsight, to find an indicator that might have suggested the true purpose of the crime. In 2012, bank staff and others who work in the financial sector are far more aware than they were 10 years ago of the importance of customer due diligence checks and the system for reporting suspicious activity or transactions. But in my knowledge, and I wait to be corrected by the authors of the Indicators report, that has not resulted in disrupted plots. The reporting of suspicious transactions has never yet led to a prosecution for terrorist financing. FATF recommendations on terrorist financing, however, are universally accepted as the standard for states to reach. The core FATF membership of 34 states includes all the permanent members of the Security Council and all but 2 states members of the G20. In all, including the membership of the FATF-style regional bodies, 180 of the 193 members of the United Nations have agreed to implement or to try to implement the 40 FATF recommendations and to open themselves to evaluation of their progress by their peers. And in the context of terrorism, the 2 most relevant FATF recommendations are Recommendation 5 on the criminalizing of terrorist financing and Recommendation 6 on targeted financial sanctions related to terrorism and terrorist financing. These 2 recommendations and their accompanying interpretive notes set out a thorough set of principles for governments to follow. I was just going to mention there that there are 1 or 2 issues I have with those recommendations, but in the presence of FATF members, maybe we'll keep that to a private discussion. But anyway, the notes are extremely useful, and they have very good things to say about the application and implementation of Security Council resolutions 1373 and of 1267, which both relate very precisely to terrorist financing and asset freezing. Also relevant, of course, to terrorist financing are Recommendation 8 on non-profit organizations, 14, 15, 16, and 32 on money transfer systems, and 20 and 29 on suspicious transaction reporting and financial intelligence units. But I'd say again, the first two recommendations, one on assessing risk and applying a risk-based approach, and the other on national cooperation and coordination, set the tone for the rest and are as significant as any other in terms of ensuring that the response to the terrorist threat in the financial sector is properly calibrated to the threat. Though FATF is in the process of drafting guidance, the issue that remains largely unaddressed, however, is the methodology by which states and designated non-financial bodies and professions should make their assessment of the threat. The interpretive note to Recommendation 1 sensibly suggests that states should identify and assess their money laundering and terrorist financing risks on an ongoing basis, keep the assessments up to date, and have mechanisms to relay the assessments to those that need them, both in the public and the private sector. But when it comes to how to do all this, the interpretive note suggests only that countries take appropriate steps. And as we all know, however appropriate the steps, the destination can often remain rather elusive. The interpretive note to Recommendation 1 also deals with the obligations for financial institutions and DNFBPs, if I can use that acronym, to assess the risk, and says that they should have appropriate mechanisms to provide these assessments to the competent authorities. Again, thoroughly sensible, but it is a shame, in my view, that FATF has chosen not to recommend that national authorities work with the private sector to identify and assess the risks. There are perhaps reasons for this, not least, of course, the difficulty of sharing classified information with the private sector. But without some enhanced dialogue between national authorities who know about terrorism and private sector experts who know about finance, it is unlikely that any risk assessment will be as rich as it needs to be to ensure sufficient and proportionate countermeasures. Or, as the interpretive note for Recommendation 5 puts it, action that is effective, proportionate, and dissuasive. The correct proportionality of measures to combat terrorism to the threat is essential to their success. The reason that terrorism survives is that it can be a successful political tactic for groups that lack the capacity or support to oppose or promote policies through other means. The objective of terrorists is to persuade a government or international organization to do something or to abstain from doing something by terrorizing their public constituencies. And killing is a means to this end, not an end in itself. Terrorists will do no more than they have to in order to achieve their objective. But if the main terrorist objective is to raise public anxiety to the level that governments are forced to change their policies, it seems perverse that governments should help them to do so. But public anxiety can be as responsive to terrorist countermeasures as it can be to terrorism itself. The checks at airports have become routine and passengers accept them as part of the cost of travel, but they do not help build the resilience of the travelling public to the idea of terrorism. These and other visible and less visible countermeasures tend to suggest that terrorists are ubiquitous and that they may strike at any moment should we lower our defences. And this is clearly not the case. But the amount of X-ray machines and concrete bollards and controls on the entry to public buildings seems to be increasing at the same time as both politicians and experts agree that the threat is in decline. As I said, the evolution of the bureaucratic response to the problem is lagging too far behind the evolution of the problem itself and has become disproportionate to the threat. So my third and, I'd say, final question is, how do we develop counter-terrorist financing techniques in a way that ensures their proportionality to the threat and the most effective use of resources? Of course, it would be both politically and practically unacceptable to roll back all measures taken since September 2001 to counter the financing of terrorism. But just as FATF recommends that countries keep their threat assessment up to date, so too must the international community keep their countermeasures up to date. And the best way to do this is through greater cooperation of states, through regional and international consultations that also allow for input and reaction from the private sector. As well as introducing better mechanisms to ensure the proper sharing of information between agencies, governments must be more sensitive to the potential contribution from, and cost to, the private sector in implementing CFT measures. They must be clear which rules are intended to regulate the financial sector and which are designed to prevent terrorism, and the line between them often appears to be pretty blurred. FATF has given great importance to consulting the private sector in designing its 40 recommendations, but national governments could do more to harness the commitment of the private sector to the overall effort against terrorism by exploiting its expertise and knowledge in a more focused way. Banks can be of enormous assistance in the detection and prosecution of crime. They know where their customers are, where they have been, and often where they are going. They know their spending patterns and their sources of income. They know their business relationships and their job history. Clearly, there are important privacy issues to do with the private sector releasing such information, just as there are confidentiality issues for states in sharing details of the terrorist threat. But within a proper legal and administrative framework, the public and private sector could and should work far more closely together at the local, national, and even international level. And this activity should take place according to a well-considered evaluation of the risks of terrorist attack. Just as CFT regulations address the international dimensions of terrorism, so too should the threat assessment. And I note that the FATF recommendations acknowledge this, if only in the footnote to interpretive note to recommendation 1 that recognizes the relevance of supranational risk assessments to national action. However, despite that, of course, intelligence is very rarely shared beyond a bilateral basis, except perhaps in the Five Eyes arrangement that exists between Australia, Canada, New Zealand, the UK, and the US. The circumspection about sharing intelligence, of course, is based on a lack of trust and a desire to protect sources. And good intelligence is both a valuable commodity and a tradable commodity, as well as being difficult to acquire. And it's hardly surprising that traditions of secrecy would be hard to break down. But even the best intelligence has absolutely no value if it cannot be used. And intelligence on terrorist threats does not need to be guided by the same rules as other political or commercial information. No state is in competition with another in the world of terrorism. The international consequences of an attack on any one country are well accepted. And it is in the interest of every state to collect and disseminate as much intelligence on terrorism as possible, provided that the mechanisms for doing so are robust enough to withstand investigation from the terrorists or their sympathizers, and provided that the supplying state is consulted before any action is taken based on the information itself. And another advantage of sharing information on terrorism, apart from the obvious one, is that it offers an opportunity to put small snippets of information into a broader context, to pool together pieces of intelligence that on their own have little meaning or significance. And where the intelligence concerns possible terrorist financing, the involvement of experts from the private sector adds to the likelihood that the interpretation and context is correct. I know financial intelligence units try to work together internationally and to bridge the gap between the public and private sector, but they need more political support and greater inclusion in the intelligence community. This may come, but their acceptance will probably follow their success, and we should think of ways to improve their image and assert their utility at this stage. The decline in the terrorist threat may lead in due course to the reduction of budgets for counter-terrorism and the diversion of interest elsewhere. But the momentum created by the response to the attacks of 9/11 will not die away quickly. While it remains, we should accept that although the regimes set up to combat the financing of terrorism have not shown obvious and dramatic results, they have contributed to the current difficulties that terrorist groups face in raising, storing, and moving significant amounts of money. They have acted, at the very least, as a deterrent also to donors. However, we should use the breathing space before another major wave of attacks forces us back into the febrile overreaction of the post-9/11 period to take a long, hard look at what we are doing and why. We need to identify better ways to measure our success and recognize our failures, and be quick to reinforce the former and be prepared to change our methodology to eliminate the latter. We must ensure that action taken to combat terrorist financing is proportionate to the threat and reflects what is going on in the terrorist world rather than in our own. And furthermore, we should draw on the investment made in all countries of the globe to understand how terrorists operate and what they plan to do. We can save a great deal of time and money and anxiety by sharing our experiences and knowledge, and at the same time we should find more efficient ways to include the private sector in our deliberations. Getting counter-terrorism right in all its aspects, including encountering the financing of terrorism, will lead not just to less terrorism, but also build the resilience of the public to terrorist attacks. This will lower the impact of terrorism and reduce its attraction as a political tool. And our success will not come from further rules and regulations. It will come from ensuring that the rules and regulations that we do have and do introduce produce the results that we want, and that we have a system that maximizes the contribution of all involved. Thank you.
Battery.
We are going to have time for questions and answers after this panel discussion is completed, and you can also direct questions to Mr. Barrett. So this is our first panel, which is titled, Are the Regulators Doing Too Little or Too Much? And that might be a slight overstatement saying regulators, because we don't actually have any regulators here. In fact, we specifically did not ask any regulators to come here today. So we didn't have any bank supervisors, et cetera, breathing down our necks, shall we say. I'll just briefly introduce the members of the panel. You have their biographies in your booklet. And let me start with Rick McDonell, who is Executive Secretary of the FATF, the Financial Action Task Force. Any of you who disagree with any of the FATF recommendations or how they've been implemented in the United States, Canada, and elsewhere, please complain to Rick.
We know where to find you.
Next, yeah, at my house right now. Next, Boudewijn Verhelst, who is chair of the Egmont Group of Financial Intelligence Units and also runs the Belgian FIU. Next, Yves, please pronounce your last name for me again.
Aeschlimann.
Aeschlimann, I was going to say Aeschylus or something. I don't know. Aeschlimann, you've told me that many times, I apologize. Who is now a senior financial sector specialist at the World Bank, but previously was an investigating magistrate and who in Switzerland, and is responsible for bringing some very nasty miscreants to book and finding the cash that they had stolen from their countries. Next, I introduce Nadim Kyriakos-Saad. No, he's not here. But we had to find somebody who also had a Greek name. And so Nikos Passas is taking Nadim's place. Nadim, he and I got into the AML business sort of together before 9/11. And it's unfortunate that he couldn't be here. He actually gave me a little statement to read as to why he wasn't here. Basically, it comes down to he had to do real work with some country that was in trouble, and his wife wouldn't let him come and spend that much time here. So Nikos is going to be speaking in his place, and Jeff Breinholt from DOJ, who has been involved in counterterrorism for so many years and who is absolutely key to identifying the terrorism-related cases that Sue, Nikos, and I had looked into to try to find out if there actually were patterns of financial transactions that indicated terrorism financing. The way this is going to run is that Rick is going to start by making a presentation. Then Yves will make a presentation, and then Nikos will make a presentation. Then we'll have a general panel discussion. And after that, we'll open this up to questions, and you will see that there are microphones here. If you have questions, come down, and you can ask them. And then after that, we'll take a break. Thanks. And somebody here who's a PowerPoint expert is going to come down here and set up the PowerPoint, which is now in the process. And does everybody have a PowerPoint? Yves, in that case, Yves will go first. Oh, sorry, Jerry. Or is it already set?
What?
Okay.
I guess, yeah.
So what? Who first?
Hey.
So, okay, go ahead.
Okay.
So thank you very much.
That was great. We didn't want to go over.
That was efficient.
Okay. All right, I'm sorry about that delay. I'm just a lawyer. Can I just introduce myself? I'm Rick McDonell. I'm the Executive Secretary of the Financial Action Task Force, and even though you don't have regulators here by intention to complain about, I guess that I'm the representative of the bête noire of the international world in relation to the movement of money. I'll try to live up to that. First of all, we had a good introduction by Richard Barrett, I think, who I'm happy to have him steal some of my thunder, because that lets me save a bit of time, because I was going to give you a bit of a rundown on what the FATF does in general. I'll still do a little bit of that, but more in particular, two presentations this afternoon. This first one is about the risk-based approach, essentially. The second one at 5 o'clock will be a little more detailed, concentrating on what we've done in relation to terrorist financing issues. For those of you who are interested, the organisers also have a larger, perhaps more boring PowerPoint presentation, which I won't deliver today, but if you feel like making it available, it will give more detail to the audience about what the FATF is doing, in particular in relation to how we have revised the standards that have just been approved. Okay. I do need to put a couple of things in context. I'll probably take 10 to 15 minutes. That'll be enough then to allow Yves to have the floor. What do? We used to do the international standards on money laundering and terrorist financing. A new standard, the beginnings of new standards in relation to the financing of the proliferation of weapons of mass destruction has just been added to the FATF's standards, and that will also be assessed in the same way, using the same methodology as we have been doing for years now in relation to money laundering and terrorist financing. In relation to assessing compliance, we've spent the last several years on what we call the third round of evaluations, which is now completed. That involves a very detailed study of and assessment of how the countries are doing in terms of implementing the standards. It involves not just the recommendations themselves, but a very detailed handbook of criteria to be used by the examining experts who go to a country and ask a lot of questions and determine whether or not the system is technically compliant. I'll come back to that point. Just in relation to the membership of the FATF, we have 34 member countries and two international organizations which comprise the core membership, and that is the standard setting body itself. We have 8 regional bodies, and we have 22 observers. We're likely to have a 9th regional body in Africa very shortly, and they in total comprise about 180 countries, as I think Richard mentioned, the coverage of the FATF. The observers I won't go through, there are too many, but we have partnerships with many stakeholders, including, of course, the organizations represented at the table here, and others, including Interpol and various other standard setters. Now, what we do, basically the recommendations set out minimum requirements for countries to comply with certain rules for detecting and deterring and eventually providing sufficient information for investigation and prosecution and confiscation of assets where guilt is shown, or in some instances information that will allow non-conviction based forfeiture of assets. The next point I have here, effective implementation, I think is a very important one to concentrate on for a minute or two. The third round of evaluations concentrated largely on trying to set up a framework, legal and administrative around the world, which essentially would provide legal tools and administrative capacities for the standards to be properly utilized. We have finished that round of evaluations. The next round, which will commence next year, will concentrate much more heavily on what has that meant in practice. What is the effectiveness of the systems in operation? What will we expect of countries to do to show not only their technical and legal adherence to the standards, but what outcomes are they achieving? So when Richard Barrett quite rightly raises some valid questions about that, I'm happy to say, better late than never, we will be aiming at achieving some of the outcomes that you mentioned. For example, the necessary partnership between the financial institutions and the FATF, I hope, will become a deeper one. They are, of course, a primary stakeholder in terms of their obligations and their inputs to the system to detect financial transactions that may be suspicious or terrorist-oriented. There's a question, of course, as to whether there's much of a difference between the two and how you identify those two things, but that's perhaps not for today. We will be looking at much deeper ways of interacting with the private sector in a number of ways, one of which is typologies, as we call it, a generic term for methods, trends of money laundering, terrorist financing, and the financing of proliferation. And we have, from time to time, interesting discussions which hopefully will lead to a more concrete outcome before too long, as between what do financial institutions know about their customers, but more importantly, what do they know about the habits of some of their customers who may be conducting activities which are not entirely legal or raises suspicions of that. And that's on the one hand. On the other hand, what do the authorities expect from the financial institutions, and what can they give in return? The bridge of information there is the one that was raised before, and I fully agree with the comments that have been made. I thank Richard for his very British courtesy in not raising too many things in public with a dirty linen, although I don't mind that at all if you want to do that. I'll be happy to try and defend the situation, but I should say, realistically speaking, we do have quite a long way to go to make sure that there is a two-way street of information flow, particularly in terrorist financing related issues, between those who have the information and who are able to understand its significance, that is the financial institutions, from the point of view of financial transactions, and those who have information about people who are suspicious and their activities. Putting those two things together necessarily requires a trusting relationship, and in terms of confidentiality, a certain amount of protection in relation to the information that's to be used. That's an obvious thing to say, of course, but it's protection of information, not just for civil liberties reasons and not just for contractual reasons of bank confidentiality, but also for reasons of tipping off people who are conducting or may be conducting illegal activity, or including terrorist activity. So it's a challenge to do that, but one that is entirely necessary. And there are ways to do so, and we will try to work on those. Obviously, the FATF is not a legal body in its own right. It's a task force, but it has national country members who have, obviously, the power to put in place arrangements and legal protections under which certain information can be exchanged. And one of the ways that can be done is to have a trusting relationship between the financial institutions, and at the same time a certain set of obligations of confidentiality on both sides, where there can be some exchange of information on a larger basis than is being done at the moment. This is particularly necessary for terrorist related activities, and we will work on that further together with the financial institutions. Now, the other major thing, apart from the risk-based approach, which I'll come to in a couple of minutes, is the risks, and how do you determine them? How do you judge what risks you face? Because the risk-based approach relies on determining which areas of risk are low, and therefore you don't need to spend too many resources on them, and which areas of risk are high in terms of your customers in the financial institutions, and therefore you can concentrate and focus more effort on those. We have a number of factors that try to identify what those risks are in the new standards, and that's a singular new thing about the revised standards that have just been adopted. The reason we've done this is manifold. Richard has mentioned some of them. We did get criticisms, and I think they were valid, about not having a one-size-fits-all approach. It's too expensive, too gold-plated. Why have a Rolls-Royce for a low-risk situation when you really only need it for a limited number of situations? And there was some inflexibility and inefficiency in the application of the rules, which leads to unhappy results, and perhaps one of the examples being unnecessary filings of information, or defensive filings, as it's often called in the financial industry. So what we'll be expecting in the future is not only the continuing application and implementation of the technical compliance requirements, but an understanding of the risks involved, and two sets of risks. One at the national level: what does a country need to know and should know about the risks it faces in relation to money laundering, terrorist financing, and the proliferation of financing of weapons of mass destruction. We're working on some models as to how countries can do that. Not many have that at the moment. Logically, once those are in place, we will be assessing their performance. But flowing from that, there should be then a necessary examination of the sectoral risks. Where do the risks lie? Do they lie in particular segments of the economy, with particular types of people, in particular regional areas, or what have you? And the examinations we'll be conducting in the fourth round of evaluations will concentrate far more on what the risks are, and therefore, in outcome terms, what have been the most effective results. We're going to be looking at effectiveness of the system, as opposed to just technical compliance. And that's what I think, again, as we're speaking in this audience, not about money laundering so much, but about terrorist financing, the focus on outcomes in terms of deterrence, prevention, and if unfortunately that doesn't work, as it undoubtedly won't always, then how do we identify and do something about people who have transacted funds that have gone towards the support of attacks? That's the approach we'll be taking, of course, also in relation to the money laundering side of things, and there will be a deeper set of inspections, I'll use that word loosely, when we do our evaluations, of how the agency is working. What is the interaction between them on a national level? What's the level of information exchange, both nationally and internationally? And what's the level of harmonious working relationships between the agencies, the officials on one hand, the private sector on the other, and regulators and the standard setters as a third aspect of that. This is a very brief overview. I'll stop in a couple of minutes and we'll have some question time later. If you're interested in a more detailed appreciation of the risk-based approach, we do have it in paper form and on our website. The paper form is a novel that size. I'm sure you won't want to read that at bedtime, but it does set out, for those of you who are particularly interested in segments, the risks and the risk-based approach factors that we apply in certain sectors. So I commend that to you at the moment, because I don't have time to go through it. As again Richard Barrett mentioned, we have a new overarching recommendation on the risk-based approach, which sets out the principles at the beginning. We have implementation applying to all the recommendations, requirements, and specific risk-based requirements in some recommendations, and clearer requirements at all levels applied as I've just described to you. So the risk assessment that a country has to adopt doesn't mean a single document. It has to mean, it means a living work that goes on regularly and has to be revisited, because some risks come and go, some risks evolve or lessen or increase. So what we'll be expecting in the future when we do assessments of countries is an up-to-date assessment by the country, which we will then take a good look at as to what the risks they face are based on objective criteria, and the assessment by the experts who do evaluations of whether that is in fact an accurate assessment process by the country, and whether then the results from applying that, that means the results in terms of building infrastructure, of making sure the operational side works, the legal side works, the financial regulatory side works, actually is producing results and is putting in place also some effective deterrent mechanisms. perhaps for the sake of introductory remarks, I'll leave it at that because you will get bored with me, as I will have another chance to speak to you again shortly. Thanks.
Nikos Passos from Northeastern, and one of the troika who worked on this terrorism financing report.
If I can, I will be talking to you about the proliferation finance aspect. And just to tie what Yves was saying earlier with the work that I will discuss now, is that if the international lawmakers and standard setters are a little confused about terrorism finance, you should see how lost the national legislators are. We did, when Michael was the chair of the American chapter of the International Association of Penal Law, I was the rapporteur general for what the national chapters reported on what national provisions are there, and you have anything from absolutely nothing to treating terrorism finance as terrorism. So if there is no terrorist act, there is no terrorism finance. And those that had laws in place that were decades old, so they had no consideration for any sort of recent activity that has taken place that precipitated the new laws. The work I would like to share with you, since the FATF now formally includes the proliferation finance in the 40 recommendations that they have, is some work that I had the honor to do together with colleagues on behalf of the European Union's Commission, that which ended last year. The other team members were Ian Anthony from Stockholm, Geneviève Dianaz from the Bank of France, and Justine Walker from the UK FSA and Treasury. And we tried to take a look. Our mandate was to take a look at what UN Security Council resolutions say, how are these being implemented, how good and helpful the FATF work has been in that effort to implement and strengthen counter-proliferation efforts, and see what policy implications that gives. I will not be very technical because we're going to take too long. I will just briefly explain to you in what kind of mess we are and how we can get out of it. The methods we had a variety of methods, and these ranged from looking at visiting countries, analyzing Security Council resolutions, EU regulations, and other texts. We sent a questionnaire to member states and other countries that we could not visit. And we reviewed in detail the FATF output. In fact, Justine Walker was the drafter of some of the FATF publications on that. And we wanted to understand a little bit what implementation means. What does it do in practice for governments and the private sector that actually has a very important role to play here. Also we wanted to review, we thought that in order to assess implementation, in order to see whether something works, you have to understand what it works against. So you need to understand how proliferation networks work. So we needed to have some cases about proliferation. That was a part of the study we were not able to accomplish because the proliferation cases were not shared. We had some cases, and on the basis of those, we were able to make some recommendations that I will refer to shortly. I'll go very quickly through this so we can have some time for discussion, but we were busy. We did travel around. These were the EU places we visited. These are the non-EU places we visited. And let's get into some of the findings. Looking into Security Council resolutions, there are different types of provisions that you find there, and they're not all, of course, about financial vigilance. You have export controls, and our team was privileged to have depth in the skills from both the financial and export control perspective. So that comes in handy because, in fact, that's where the answer lies. Unless these type of controls not simply are used well to complement each other, but get integrated, we're not going to get anywhere with controlling proliferation. So, Security Council resolutions provide for export and border controls, financial vigilance, activity-based prohibitions to look at particular type of activities and stop them, freeze assets when those who have been identified as involved in proliferation activities, you take those assets away. Specific vigilant measure, there's some naming of particular actors that banks, financial institutions, and others need to look out for. And then you have things that are very practical about international cooperation, how you share data, and how we help each other, technical assistance, in implementing those provisions. Those require legislative action in many respects, and at the same time practical measures that are preventive as well as monitor intelligence gathering and enforcement. And some provisions there are particularly about the financial sector and what banks and other financial institutions need to do in this respect. There are some problems. And the problems, as Yves was saying with respect to terrorism finance, are multiplied here because we have multiple issues here. By the way, proliferation, we talk about when it is a state actor involved. If it is a non-state actor, then we're talking about terrorism finance. So that is one of the links between terrorism finance and proliferation finance, right? But as was the case with the intent behind terrorism acts, the intent here is unclear about what the drafters of Security Council resolution actually want to accomplish through those resolutions. So when generic mandates are introduced, the question is, what does that mean in practice for the government in order to do something, comply with, and how can it encourage the financial services and other companies to comply? There are even some particular terms that may appear to be easy sort of to conceptualize, like an Iranian bank. Okay, so there are some issues about Iranian banks in general. But what do we mean by that? An Iranian bank that is so registered, or an Iranian bank that, or a bank that is actually controlled by Iranian actors? And so you can get, when you sort of start digging in and getting into the nitty-gritty, it gets much more difficult than it appears. And the question then is, where is the authoritative interpretation? Where is the guidance? Okay, so the intent is not very clear sometimes, also because one has to distinguish between sanctions and counter-proliferation. They do accomplish things, but they may be different. You can be very successful in sanctioning an entity or a country, but this doesn't mean that you have stopped proliferation. And in fact, you may have produced other unintended effects, such as criminalization of actors and activities that otherwise would have remained above board and therefore monitorable. The other sort of problem that we have with Security Council resolutions is which of them, and if not all, are actually mandatory. Because the majority of them are under Chapter 7 of the UN Charter. This generally means that they automatically become part of domestic law. But there is differential language within Security Council resolutions when member states must do something, shall is the operative word, or are encouraged to or are called upon to do something. Some would argue that if it's under Chapter 7, everything is mandatory. Others would say there's a reason why we have different language. It means something in practice. Go figure. Then you do not have only one Security Council resolution. You have, as you can see here, the top bullet is non-state actors, starting with 1540. Then you have those that regard the North Korea. Then there are others that regard Iran. These were the 3 sets of Security Council resolutions that we concentrated on. We couldn't do absolutely everything. There are other resolutions that don't have financial provisions in there. But again, going back to how you interpret different words, reasonable grounds to believe, entity under control, what exactly does that mean? You have to operationalize that, you have to act on that, and there is no guidance on how you do this. The FATF has done some work, we'll come to that in a second. But things get even more complicated because there are unilateral sanctions as well. Before we get to single state sanctions, we have also the EU as a group, where you have regulations that go beyond what is required, mandated, and sanctioned by UN Security Council resolutions. Although these regulations are to implement what the UN Security Council has provided, here where we have also inclusion of other measures that go far beyond what was agreed at the Security Council. Okay? So there you have actually proliferation of regulations. 9 on DPRK, 23 on Iran, and that's counting until last year. I think we have to update the numbers a little bit. So what the EU regulations mean is another layer of interpretation that needs to be put in place. And imagine now you're sitting as a compliance officer trying to comply with everything, and you operate in the EU, you operate in other parts of the world, so you are subject to everything that applies. The FATF has been helpful and has initiated, in fact, not only provided some examples of proliferation in a sanitized form in 2008, but it also provided some reports on what needs to be done on policy and some guidance with respect to what is meant by some Security Council resolutions. Would not go anywhere beyond that, although, as I said, the difficulty has been that it is not just the Security Council resolutions that matter. When you are in the private sector, you have to comply with a lot more. Now, there are also expert panels and committees that monitor the implementation and do some work with technical assistance, guidance, and so on at the UN. The countries are required to report what they're doing about that implementation, therefore, to such bodies. We looked at those reports, and I can tell you that not all countries have actually reported anything at all. Others that have reported is pretty much sort of, yeah, this is what we have done, or they have gone as far as, the radical step of notifying certain ministries or financial institutions that there is this Security Council resolution. Although I can tell you that in some countries I found out that high-level government officials were unaware of these as of last year. We have also found that in some countries you have extremely weak systems. When they do report, they have done something. Some have good export controls, but not very good financial controls. Some have financial controls, but nothing about exports. Some have bad controls all over the place. And some do not have even the political will to introduce them. They have perhaps other priorities or other issues to worry about. And even those countries that do care about proliferation and about the particular countries on which there is a broad consensus on the need for counter-proliferation, even there you see that domestic coordination, integration, and consistency is actually lacking. Add to these UN and EU sets of standards, what the US is doing through OFAC. Add to that what other countries do, but primarily the United States, which also goes far beyond what Security Council resolutions say. And add the fact that their application is not only about anyone who lives and operates in the United States, but extraterritorially as well. Okay? So you operate elsewhere but act in dollars or in euro, you have to pay attention very closely to what is happening there, right? So international financial institutions have this challenge, and also those that operate in jurisdictions with those currencies clearly have no clarity on what they are supposed to do. They want to do the right thing, and believe me, I haven't seen any banker who doesn't mind doing some business with proliferators. Okay, the same applies to logistics companies and so on. They are a natural partner in this business. They can do it, however, without some kind of specification. FIUs, we have found, that do not feel themselves qualified to actually deal with even a SAR when one is filed about something that deals with proliferation, because I think that is related to export issues, and other authorities are better equipped to look at that. So the challenges. Awareness and familiarity. We found that in many parts of the world, people didn't even know what it is about. I think that even the fundamental issue of what is proliferation, why does it matter, how can I help, what do I see if I want to help, how can I analyze it, spot it, and then report it properly. That sort of work, groundwork, needs to be done on a massive scale, and it has to be done not just with financial institutions. You have to have people who deal with exports, you have to deal with people who deal with logistics, you have to deal with people who do sensitive work, and it is not only dual use and listed items that you have to pay attention to, because as we know from trade-based money laundering and financial crime through trade, you can use trade for two untoward purposes. One is to hide sensitive or prohibited commodities. The other one is to hide illicit payments through misinvoicing or other methods. So you've got to pay attention to trade for these two reasons. The challenges are also commercial and competitive. There are commercial interests involved, and some are more reluctant than others to comply and say, this is our priority, this is what we want to do. And believe me that in some instances, it can be quite tempting to turn a blind eye to what is going on there when there are no incentives for control. The capacity in many parts of the world is simply not there. Even if the will is, they just can't cope with what is involved here. And when it comes to trade issues and how, I can tell you, and we were here 2 years ago, we were talking about this, you can go back to the webcast. What I was presenting at the time was informal payments and trade connections, and how you can do money laundering and terrorism finance or other things through trade. The same thing applies to proliferation. You can have elephants go through hundreds of millions of dollars, can hide in commercial activities in the trillions of dollars of daily transactions that do not smell suspicious necessarily. Okay? So if we in the North have a hard time understanding the significance of commercial flows and what they may hide, you can imagine how countries in the South are much more challenged to do so. So capacity is a serious issue. When it comes to international cooperation, there is a lot of sensitivity about all of these things, but even when a proliferation case is identified, it is like pulling teeth, worse than when it comes to terrorism, where the stakes are much smaller. With sharing that information, communicating that even to other authorities. Intelligence agencies notoriously will not tell you what they know, will not share necessarily what they know with others, and they will allow things to go on even if that eventually leads to acquisition of technology that shouldn't be where it is. And the analytical and conceptual rethinking is about what does proliferation finance control actually means. Because if we're talking about only getting the banks involved, it just doesn't do it. And the banks are not the player that is best equipped to pick up those things, with very few exceptions. There are some instances where suspicious activity reports did trigger proliferation cases. So we do know that there is added value there. There's no doubt. But this cannot happen unless we understand the need for integrating financial flows with commercial flows, with informational flows, the three global flows. Make them traceable, make them comparable, match them, and find out where the irregularities are, and then go and investigate them. Because, by the way, when you identify an irregularity, it doesn't tell you that this is proliferation, or that is corruption, or this is tax evasion, or that is terrorism finance. That will be found out at the end. And when you have a fragmented law enforcement community that needs to receive a suspicious activity report or other information about an activity, you will not know in advance which is the most relevant agency. Is it drugs? Is it tax evasion? Is it human trafficking? It could be anything, but it could be proliferation finance. In the meantime, the SAR may be sitting there collecting dust without going to the proper agency for investigation. So we need to bring together in the same room and in the same database as the capacity exists in the United States and other countries, those kinds of flows, and turn the lights on in a shadowy economic activity, economic space that is currently not being monitored. Okay? What is, as you can imagine, with all this attention and proliferation, what we do see is a shift in the methods used by proliferators. They're not going to use sensitive data. They're not going to go through the front door. They're not going to go through suspicious countries. They will go through third countries. They will go through parts. They will go through fourth, fifth parties in order to do what they're doing. That needs to be, so intermediaries and nominees are going to be used increasingly. The criminalizing effects are that unless you're careful on how you apply sanctions, a whole lot of legitimate trade and commerce and financial activity will go underground, will become criminalized. And the problem with that is not only that you can't monitor it, it is that even after sanctions are lifted, the criminal networks are going to be in place and will stay for much longer. Once a criminal infrastructure is put in place for one reason, it can be used for others. If you know what to bribe in order to smuggle a human, you can smuggle drugs next day or something else the day after. More pressure on the financial sector means that you're going to have informal economies, informal methods used more. The more of this goes in that way, the less we can monitor, the less intelligence will be collected, the more proliferation is likely to happen. I have only 1 minute. I can send you the report. I don't think that I can go through the needs and recommendations that we have, but we clearly need guidance. We need to understand how proliferation works. We need to see how the risk-based approach can apply to this part of public policy. The seminars and technical assistance, by the way, we do get credit. We do say that we have now capacity in certain areas, but I can tell you that in most countries, whether that regards banks or logistics companies or exporters, unless somebody stays on and there is continuing guidance and provision and sharing of knowledge, they can't do anything. They will fail. They will just go back and they will continue doing what they were doing before the seminar. So that paperwork, that certificate is not going to go very far against proliferation. The private sector is absolutely essential. And here's an example of a proliferation case where paying attention to the financial aspect does reveal it. In this example, the end user uses a front company in order to get the commodities. This is the top set of transactions. So if you're monitoring exports, you have the false end user and you will not identify the proliferator. But if you looked in this case at the financing aspects, the bank, then you can see that there is a direct connection without the intermediary, without the nominee. So sometimes in trade, they hide who is the intermediary. Sometimes they hide who is the financier. But unless you put these things together, you miss cases. This is the case, this is the case where the letter of credit goes directly to the Asian end user when the goods go through a front company. Sorry, it wasn't the previous one. It is this one. So trade can be used for a number of crimes. This is a list. You can see it, and it's going to be on the webcast, so you can see it later. I don't need to go through that list. But the point is that there is an answer. There is a way. There is a technology. The data are there. It is a matter of just putting them together. You take the import-export statistics. You take the logistics. You get things from peers. You get things from the traders and the brokers and the shippers. You put it together with what financial institutions have, and that is how you turn on the lights into what is now a dark area. This is how you can actually follow the goods without having to create new rules, new regulations, new data. I'm sorry I don't have the time to explain this further, but mapping the illicit networks, finding out how these things work, providing the guidance can only be done when you have a public, private, academic partnership where you can have the data, you can have the analysis, you can have the conversion of that into something that is policy useful. It helps with lawmaking. It helps with better regulations. It helps with realism and pragmatism, what can be accomplished. It consolidates the partnership between the private and the public sector. And we do have also anticipatory analysis. If we do this, what will happen next time? What are they going to do? How will they adapt? And this is what we are doing at Northeastern. We have a new institute with $12 million. This is the building where all kinds, 70,000 square feet facility for all kinds of security kind of work with the specifications of the US government that lends itself for also private sector kind of meetings. So the private, the public, and the academic communities can get together there. We have anything for heavy duty technology sort of driven work with the policy work. We have Steve Flynn, Peter Boynton co-directing that, and thank you so much. I'm sorry I don't have any time to say anything more.
Thank you very much. I think it's time now to throw this open, particularly to the two folks who volunteered not to give a presentation.
Okay, does that work here? Okay. Well, let me add something to the discussion. First of all, I need to point out that I'm a bit the odd man out here. You know, I'm not a regulator, I'm not a supervisor, I'm an operational. It's about the financial intelligence units, you know, as an operational unit, even if some FIUs like FinCEN perform regulatory duties. So I'm looking at it from a operational point of view. Now, we are not standard setters as such, but of course the Egmont group, which actually focuses on the international cooperation, exchange of information at FIU level, has done its bit also in developing standards like the FIU definition. That is, the Egmont definition has been transposed in different instruments. Even the FATF has taken it on board. And what we also advocate, and which is also now becoming a standard, is that the FIU needs to be able to exercise all domestic powers also within the context of international exchange, international cooperation at FIU level, which is very important, although we still have no general standard on how a FIU should conduct its assignment. It says what an FIU does, receiving, analyzing, and disseminating, but how you do it, and that's where you have all the disparities. That is actually one of the main challenges in international cooperation at our level. But coming to what I've heard here, and that is, let me add something about from a not only practical but also legal view, legal point on the TF discussion. Are we sure that we all agree on what a terrorist organization is? Because financing of terrorist organization, for the one, is he might be a foul terrorist or a terrorist organization. For the others, he's a freedom fighter. Chechnya. Let's be very, very concrete. For the Russian Federation, for the Russian FIU as well, I mean, Chechnya, that is full of terrorists, whereas the same people get political asylum in the European Union. So do we agree on what a terrorist organization is? And what is the importance here? Is that when we, at FIU level or even at police level, we receive a request for information to use our specific powers, for instance, to collect financial information in relation to a financing of terrorism, which is related to the whole Chechnya situation. What do we do? Because basically, also under the Edmund rules, we are under if not a legal, a moral responsibility or a moral duty to respond. This is not very, very theoretical, because a few years ago, our FIU forwarded a report to the public prosecutor on what we called financing of terrorism, financing of a terrorist group. Actually, it was a PKK, the Turkish PKK. Now, that became an enormous investigation, and okay, they brought the case before the court. And the question was, are we dealing with a terrorist organization, yes or no? Otherwise the whole case. Now, in the end, the case exploded on a technicality. And I'm quite sure the judges were quite relieved that they found it, you know. Because at that time, the PKK was a terrorist organization in Germany, and it was listed as such, but not in Belgium. So this is also something that we have, that I think also from our perspective, from those who actually have to implement the standards, and we are being called to demonstrate our effectiveness in that, is that I would like to have, personally, I would like to have an international standard on what the terrorist organization is, actually.
Actually, let me get up here, because I have a slide I'm dying to use. I'm going to try to give you, just in one single slide, something I think is very useful for what we've been talking about. And it's very simple, and it's actually, I think, cries out for attention when it comes to what ails us. Because I think we've heard a lot about information sharing. How do I start this?
It's down at the bottom, next to 39% on the left.
Oh, down here? Here we go. This doesn't look very simple, but this is an official page out of a official publication known as the CIA Consumer's Guide to Intelligence. Okay. For our purposes, this is far too dazzling. This is true CIA form. They try to dazzle you with all the stuff they're doing, and they try to make it sound sneaky and highfalutin. But for our purposes, there are two components that are relevant. There are collectors and there are consumers. Collectors are those people within a government that are constantly monitoring a certain type of information. That's what they do all day. They review newspaper articles. They can review satellite reconnaissance. They can review financial intelligence, which is a big one. They can review human source intelligence. They basically their heads are getting bigger and bigger as they work. They have to have consumers to be happy. Consumers are those people who have the official role within a government to unleash a certain government action. It can be the military, so-called kinetic actions. It can be law enforcement, the criminal justice system. It can be something a little softer, like diplomatic overtures and initiatives. It can be economic sanctions for treasury people. So those are all examples of consumers within our government. Collectors and consumers have to have each other. If you show me a collector who does not have a consumer, I'll show you a very unhappy person. That person is just getting inundated by facts, and they have no outlet. Consumers are constantly telling the collectors what it is, how it is they want them to recalibrate their collection. And so the goal is a cycle that goes around and around And the ultimate goal of this process is what is called actionable intelligence. That is information that, according to the tradition of the consumer, is reliable enough and trustworthy enough and timely enough to actually unleash a certain action. Okay? If you understand that, let me ask you a question. What is FinCEN in this equation? What is FinCEN? Are they a collector or are they a consumer? What is an FIU?
Any financial intelligence.
Any FIU, would they be a collector or a consumer? Most people say collector. Of course. What about the relationship between the FIUs and the banks? Right? In that sense, the FIU is the consumer and the banks are the collectors. Right? Because the tasking, that's another intelligence term, the tasking from the consumer to the collector in that second paradigm where the FIU is the consumer takes the form of Bank Secrecy Act regulations, right? They tell banks what it is we want to see. We want to see cash transactions over $10,000 and anything suspicious. So FinCEN has a dual role. They're both a collector and a consumer, and this is, I would say this is probably true of most FIUs. The question of this panel and the question of the next panel is, are the regulators doing too much or too little? Is FinCEN a regulator? FinCEN will light banks up if they're not sufficiently diligent when it comes to BSA compliance, Bank Secrecy Act compliance. But they're not really the ultimate consumer of this information. The law enforcement is, right? Because FinCEN has this role of being both a collector and a consumer. So when I say this shows you what ails us. What ails us is that ideally the intelligence cycle should benefit from a very close symbiotic relationship between collectors and consumers. And this ideal doesn't yet exist within the financial community because the regulators of those financial institutions are different from their consumers. We've heard it said that for all the work that is done to support law enforcement under the BSA and under suspicious activity report filings, no word of that gets into the hands of our regulators, who are the ones who are going to light us up at the end of the day. It's not best practices, it's worst practices. That's the way of making examples out of banks. So I hope this made sense to you. I hope this actually, hopefully in the few minutes we have, I think this is a very simple concept, but especially for the benefit of students and practitioners out there, and actually for our experts as well, I think it's a very important concept. With that, I'll step down.
Yeah, there'll be. That kind of put things into a nice nutshell, and how effective FIUs are, whether they're actually being just collectors or consumers, because I think often, Boudewijn, you might probably agree, often they're not being so much consumers, they collect and then nothing happens. Not in your case, obviously. Oh. Not in your case. Any more discussion here before we throw things open to questions? Then anybody have any questions would like to address our learned panel or Richard? All issues have since been, remember there are no supervisors here, and I know there are many bankers here.
Okay, so suppose some regulator, they examine an organization, or they examine a charity, and they say, well, we found that your charity has ties to terrorism. Is there any case where they say, look, we can either freeze your assets or else we can give the money to those needy people who you have designated to receive the money in terms of providing them with food and medicine and other things that they need. And if so, do you think that that this strategy might might reduce the amount of terrorism or the amount of incentive to commit these acts.
Yeah, is it on? Yeah. I was involved heavily in prosecution of terrorist financing cases, and in particular those dozen or so cases involving charities, and I can tell you that we always were worried about what would happen. It's a little bit different from your scenario in that we would actually name as a defendant the charity in the criminal indictment, and that would cause them to be defunct. What do you do with the money? And in the case of the Help the Needy Foundation, which we prosecuted up in Syracuse, we ended up finding, I think Richard and Sue and Nikos wrote about this in their report, they ended up finding a like-minded charity to basically take the assets into receivership. I can tell you in the outrageous case of the Holy Land Foundation, OFAC agreed, because Holy Land Foundation ended up being designated itself by OFAC, and when that happened, you couldn't touch the money. And so we ended up, they ended up licensing that money out to criminal defense attorneys to defend the good name of the Holy Land Foundation, which was not to the benefit of the donors. Now that there have been enough liquidated successful claims against Hamas for terrorist attacks that killed American citizens, the plaintiffs' lawyers in those cases are eager to get their hands on that money, which in some people's minds is a kind of a neat idea, is you take money that was designed to embolden and to enrich Hamas, and you give it to Hamas's victims, and so that's how we handled it in those two cases. But I think you raise a very good question. That is, I think one of the sub themes of your question is whether there's any such thing as an informal agreement to go easy on a charity that might have been unwittingly providing support for terrorist organizations. And I can tell you, OFAC does that all the time. They frequently will resolve controversies in a kind and gentle way, if you will. Does that answer your question?
Somewhat.
Okay.
I came in this morning and now I've heard 2 hours of all the problems and the concerns that you have in putting together the overriding guidance. But I work in the private sector as a banker, and suddenly I know more than I wanted to. But I was wondering if you could talk more specifically about the more common everyday transactions, some of the trillions of trade transactions or the financing transactions. I deal with sums of money coming into North America from Asia these days for investment purposes, and it's a very daunting task dealing with some of the investors to get the information that we need in order to comply in our standard boilerplate. And I'm wondering if there isn't something that we can do specifically in a self-serving way to get the answers to the questions without asking our investors, is basically what I'm saying. Anybody?
I think that question, I think, illustrates something that is a very common dynamic, and that is industry oftentimes, when it comes to due diligence, it frequently falls on the government to define what it is, and the government would rather not define due diligence, because once you define it, it becomes the floor as opposed to the ceiling. And you want to promote great due diligence among private actors, because that's what the regulatory requirement allows. I can tell you that you're in good company, because this is what we hear all the time, and my remedy for that would be for there to be closer cooperation between law enforcement, not necessarily not as much FinCEN, but law enforcement and the private sector. I mean, wouldn't you love having a government agent tell you that the group of investors that you're thinking about doing work for are going to be indicted or are bad characters who might be designated at some point. To your direct question, I'm not sure. I'm not in the private sector, so I can't really comment about how you would do it in terms of trade draft, how you would ask those people. But I think your question stands for the proposition that we need to do more to give comfort to the private sector on what their requirements are.
I'll give you 30 seconds
Sure.
real quick on what we do. We have a subscription agreement for somebody who needs to sign that before they wire the money in. And there are a couple of paragraphs in there basically saying that they comply with their status as a certain type of investor, and they are in compliance with any anti-money laundering law related to either their own country or the one in which they're investing, and that's basically about it. The problem is that the more you talk to the investors, the more you learn about who they are. In some cases, we're talking about state-owned enterprises in China these days, and I think we all remember, some of you aren't old enough, but Mr. Wang Jun and the Lincoln Bedroom and his leadership of China International Trust and Investment Corporation and the monies that came in illegally for certain types of purposes that were related to the Lipo Group in Indonesia and campaign financing. And then, of course, my boss doesn't want to hear anything you have to say about this,
right.
But I'm in the position where I have to find how far we can stretch this rope.
Right.
And it's very difficult to do so, the more jurisdictions there are involved.
Mm-hmm.
But no one would like to see more uniformity in the application, as well as the letter of the law,
right.
than the private sector.
Right.
Because there's no predictability these days. And God forbid we get one lawyer for, let's say, Cayman's counsel that doesn't agree with Canadian counsel, or
right.
doesn't agree with New York counsel, and the whole transaction gets unraveled. In the meantime, the investors are throwing their hands up, and this actually happens every day to me.
Yeah. Are there any fatter standards that you can point to that would?
Other than engaging, Professor Pasas in the Northeastern University, a new organization you've set up.
50% to them, 50% to us.
And how much to Yale?
In a previous life, I did legislative guides for the implementation of 2 UN conventions, one against transnational organized crime and one against corruption. The point in these tasks was to understand the intent of those who negotiated the instrument, so I worked with them, but to explain what needs to be done to implement without interpreting, because every single word in those documents was negotiated to bits, and using synonyms doesn't work. Something equivalent to this is what is necessary with respect to, say, proliferation finance. You do not want to endanger the consensus that was reached for coming up with these standards. But you need to explain in practical terms what does it mean, and you need to give some good examples of how different countries have gone about implementing that. And you can do that with different legal systems and different geographic locations and the private sector, and here's something that can be done. Now, with respect to that initiative, we don't judge. Actually, Northeastern has invested in this. We are working with a global financial institution that more than complies. In fact, they are thinking outside the box. They're doing a lot more. And what we are helping with is enhance technologically the compliance approach, the due diligence that they do by reading intelligently the internet and the press, by reverse engineering some of the good work that their compliance people and the staff have done leading to successful SARs, and also to reducing the number of names that they have to work with on lists that are there to something that is manageable, so that they can actually, instead of 2.5 million names to deal with, to bring it down to 150,000 or less, so they can work on that. Now, the benefit of that is this. You're not going to work only on proliferators or terrorist financiers, because in those names you're going to have bribery, you're going to have tax evasion, you're going to have organized crime, you're going to have fraud against you or credit risks to the company. So here is the synergy. You identify bad issues that benefit your company and affect the bottom line. You save on automating the process, and you save by doing better your job with lending with your customers and their partners and so on. So there is a win-win situation there, but I can tell you that for the moment, this is experimental. We just started. And as soon as we have some positive results, all of you will be welcome to participate.
I have one more question, if I may. I don't want to take up too much time, but I'd like to know if you could tell me anything about what, if any, structure there is in Asia, among the Asian countries, with respect to anti-corruption, because the only contact I have right now is the occasional telephone call from the embassy in Washington for China about who I'm dealing with, because they're very concerned about anti-corruption and the tremendous amount of embezzlement that's been publicized within the last year and a half or so. And being involved in cross-border business all the time, they look to those people who are, in a very simplistic way, they pick up the phone and they say, who are you dealing with and what do you think? They're asking us, frankly, about the integrity of the investors who are coming in. Of course, they're all AAA as far as I'm concerned. But I would like to know specifically whether or not China or Singapore or Japan or Korea are doing anything on their own to work with you or to try to comply with the UN 1337 or whatever other guidance there is.
Actually, the government of China has sponsored the establishment of the International Association of Anti-Corruption Authorities. On their behalf, I just finished a global directory of anti-corruption agencies, and there are contact numbers, and there are multiple agencies in every country. So we did that with the support of the Brazilian government, but that you can do by going to their website. It's going to come on their website in a couple of weeks. The other contact is the Anti-Corruption Academy in Kuala Lumpur. They're doing very good work. And a number of countries have, many in fact in Asia, have websites for the anti-corruption commissions or specialized agencies with direct lines for reporting anything that's suspicious.
I think we're going to break in just a second. I would also add, going back to the Financial Action Task Force and the mutual evaluation process, China is part of the FATF. The rest of Asia is part of the Asia-Pacific group, which Rick knows quite a bit about as well, since he started that one before he went to the FATF. And under the 2004 recommendations, and now continuing in an enhanced form, and the current recommendations are recommendations for politically exposed persons, which is a terrible term. When we were discussing this, I went out and got a trench coat and walked in, a different type of exposure. But which is basically politically exposed persons. I would leave it to Rick to describe, but are folks who could be in a position to embezzle, take bribes, et cetera, from foreign governments, and with ever since what was then called Recommendation 6, countries are supposed to implement heightened or I should say their financial institutions, heightened due diligence measures for customers who might be corrupt dictators, shall we say, or others who might be embezzling money. And then through the mutual evaluation process, the FATF or the Asia-Pacific group have done evaluations and assessments as to whether countries are adequately implementing these recommendations. And of course, that's all available, including ratings, whether they're compliant, partially compliant, et cetera, and that's available on their websites. Rick, would you like to?
Just not so much on that. Politically exposed persons maybe is another topic that's more general, but to answer your question, unfortunately there's no one-stop shop for the type of information that you're looking for. There are some of the anti-corruption agencies, as Nikos has mentioned, in Southeast Asia and East Asia, which are quite efficient. They're more in the capacity, though, of seeking information from people than giving information out. So it's at this stage, at least, a matter of doing it one by one, seeing what a trusting relationship you can establish and whether or not they're able to give you information. But to my knowledge, Nikos, I don't think we certainly don't have a standard in relation to that particular exchange of information, nor is there, to my knowledge, any mechanism in place to allow it in a consistent, systematic fashion.
Well, yeah, that's part of the problem. First of all, you will see that different tasks on anti-corruption are widespread. Sometimes it's a police organization, sometimes independent. The UN Convention Against Corruption mandates an independent agency, independent from parties and government, to do this. But sometimes they're appointed or financed by the government, so their independence is a bit of a question mark. In some instances, heads of anti-commission agencies have been under investigation for corruption. So there are all kinds of things that are going on. So yeah, of course, you will have to look. And indeed, in every country, there's more than one anti-corruption authority. That was the main finding here. In some, you have more than a dozen countries. One is for reporting, one is for analysis, one is for strategy, one is for international cooperation, mutual legal assistance, one for prosecution, one for assisting the prosecution. But send me an email if you want.
So we'll take a coffee break and be back, I think, in 15 minutes.